Guide to Medical Malpractice Lawsuits in Ohio. A bad medical outcome does not automatically mean medical malpractice, but if a healthcare provider missed a diagnosis, made a serious treatment error, or failed to provide care that met the accepted standard, you may have important questions. And Ohio law gives you limited time to act. In this video guide, we'll explain what medical malpractice means, what you must prove, what evidence matters, Ohio's strict deadlines, why expert testimony is usually required, how these lawsuits work, and what damages may be available. If you have questions about a possible medical malpractice claim, contact Zoll Kranz. You do not need to know whether you have a case before reaching out. An attorney can review the basic facts, explain what information may be needed, and help you understand the deadlines that could apply. What is medical malpractice? Medical malpractice, often referred to under Ohio law as a medical claim, generally involves negligent medical diagnosis, treatment, or care. Depending on the circumstances, these claims may involve misdiagnosis or delayed diagnosis, surgical or anesthesia errors, medication mistakes, failure to monitor a patient, birth injuries, failure to recognize worsening symptoms, inadequate follow-up or discharge instructions. However, not every bad result is malpractice. Medical treatment can involve known risks and complications, even when appropriate care is provided. The important question is whether the provider failed to meet the applicable standard of care and whether that failure caused harm. What must be proven? To bring a successful medical malpractice claim, a patient generally must prove several things. First, that a doctor, nurse, hospital, or other healthcare provider owed the patient a duty of care. Second, that the provider failed to meet the applicable standard of care. In other words, that the provider acted differently from how a reasonably careful provider would have acted under similar circumstances. Third, that this failure caused the patient's injury. It is not enough to show that something went wrong. The evidence must connect the provider's conduct to the harm. Finally, the patient must have suffered actual damages, such as additional medical treatment, lost income, disability, pain, or emotional distress. In most cases, expert medical testimony is necessary to explain the standard of care, whether it was violated, and whether that violation caused the injury. Ohio courts recognize a limited exception when the issue is within ordinary common knowledge. Who can be held responsible? Potential defendants may include doctors and surgeons, nurses and physician assistants, anesthesiologists, hospitals and clinics, nursing homes or other care facilities, employers or healthcare organizations. The appropriate defendants depend on the facts, including who provided the care, whether that person was an employee or independent contractor, and what the medical records show. What evidence matters? Medical malpractice cases are usually built on detailed evidence. Important information may include complete medical records, test results and imaging, prescriptions and medication records, discharge instructions, medical bills and future treatment estimates, employment and wage records, photographs of injuries, a timeline of symptoms and treatment, names of potential witnesses. If you believe something went wrong, continue receiving appropriate medical care, request copies of your records, and write down what happened while the details are fresh. Before signing a release, accepting a settlement, giving a recorded statement, or making detailed statements online, consider speaking with an attorney. An experienced attorney will help you to gather all necessary information to build a strong case. Ohio's time limits. Ohio generally requires a medical malpractice lawsuit to be filed within 1 year after the claim accrues. That does not always mean 1 year from the date of treatment, because the accrual date can depend on the facts of the case. Ohio law also allows a properly prepared written notice to be sent before the 1-year deadline expires. In some circumstances, that notice provides an additional 180 days to bring the lawsuit against the person who was properly notified. Ohio also has an outside 4-year limit, known as a statute of repose. There are limited exceptions, including certain situations involving minors, individuals of unsound mind, foreign objects left in the body, or injuries that could not reasonably have been discovered earlier. If the claim involves a death, wrongful death claims generally have separate rules and a 2-year deadline after the date of death. Survival claims and other exceptions may involve different deadlines. So prompt legal review is especially important. The facts of each case can affect a claimant's statute of limitations, so it is best to consult with an experienced Ohio medical malpractice attorney to ensure you are filing within the time limits. Failure to file within the statute of limitations may bar you from making a claim and filing a lawsuit. The expert affidavit requirement. One reason medical malpractice cases can take time to investigate is Ohio's expert affidavit requirement. Generally, when a medical claim is filed, the complaint must include an affidavit of merit for each defendant where expert testimony is necessary. The qualified expert must review the reasonably available medical records, understand the applicable standard of care, and state that the standard was violated and caused injury. In some circumstances, a court may allow additional time to obtain the affidavit. This requirement is one reason it is important to contact an attorney before waiting until the deadline is approaching. An experienced attorney will have the resources and network needed to gather the affidavit for your claim. What does the lawsuit process look like? A medical malpractice case typically involves several stages. 1. An initial consultation and review of the facts. 2. Collection of medical records and other evidence. 3. Review by qualified medical experts. 4. Filing the complaint and serving the defendants. 5. Discovery, including written questions, document requests, and depositions. 6. Additional expert review and testimony. 7. Settlement negotiations or mediation. 8. Trial if the case cannot be resolved. Many cases resolve before trial, but medical malpractice lawsuits can be complex and take time because the parties must analyze both the medical evidence and the legal issues. What damages may be available? Depending on the circumstances, damages may include past and future medical expenses, rehabilitation and long-term care, lost wages or reduced earning capacity, pain and suffering, disability or disfigurement, emotional distress, loss of enjoyment of life, other economic and non-economic losses that can be tied back to your injury. Ohio generally does not place a limit on economic damages in medical claim cases. However, non-economic damages, such as pain and suffering, are generally subject to statutory limits. For many injury-based claims, the limit is the greater of $250,000 or 3 times the economic loss, with maximum limits of $350,000 per plaintiff or $500,000 per occurrence. Higher limits may apply in certain cases involving permanent and substantial physical or functional injuries. Wrongful death claims and claims involving government entities may follow different rules. Contact Zoll Kranz, experienced Ohio medical malpractice lawyer. The most important thing to remember is that a bad outcome does not automatically prove malpractice, but you should not wait to find out whether you may have a claim. If you or someone you love may have been harmed by negligent medical care, contact Zoll Kranz to discuss what happened and learn about your options. Our firm offers completely free, no-obligation consultations, so you can get answers to your questions and start on your pathway to recovery. Zoll Kranz also operates on a contingency fee basis, so there are no upfront legal fees for our services. Our clients only pay legal fees after they are awarded compensation for their injuries. We operate on a strict, no-win, no-fee basis. You will incur no upfront legal costs as we cover all expenses related to your claim. This reflects our full dedication to securing the outcome you deserve. It is important to note, this video provides general information only. Every medical malpractice case is different, and speaking with an attorney is the best way to understand how Ohio law may apply to your situation.